Good morning. Our second case is 2018-743, the State of Ohio versus Michael C. Horn. For the appellant, Mr. Miley.
Chief Justice O'Connor, and may it please the court, Andrew Miley for appellant Michael Horn. With me on brief is Neil McElroy and Ron Miley. We reserve 5 minutes for rebuttal. Your Honors, this was an extremely high-stakes criminal case. And after reviewing the evidence that was admitted at trial and anticipating potential appeals, the state had a unilateral choice to make. And the prosecutor elected to proceed solely under revised code 2907-02A1C. 2907 is the sex crimes chapter, 02 is the rape statute, and A1C is a plainly worded provision underneath that statute that specifically requires the government to show that the defendant had sexual conduct with another person and knew that the other person's ability to resist or consent was substantially impaired because of a mental condition, a physical condition, or because of advanced age. The statute does not mention the age of minority. It does not mention a supposed power dynamic, nor does it mention a familial relationship. Therefore, these three items cannot be the basis of guilt under A1C, which is what we're here on today, even though they may lay a foundation for guilt under A2, maybe under A1B, under the sexual battery statute, or under the unlawful sexual conduct with a minor statute. Faced with this problem, what the state is inviting this tribunal to do today is collapse A1C into A2 by judicial fiat. In contrast, what Mr. Horn is asking this court to do is to just enforce A1C as it was written by the legislative branch and signed into law by the governor of Ohio. Our proposition of law is inarguable. The only difficulty in this case is applying that proposition to the record and then deciding what the remedy should be. As to count 3, JS, that's the stepdaughter. There is no record evidence, or even really any serious contention before this court, that this person suffers from a mental condition or a physical condition. The state just wants to analogize to A2, threat of force, but that would violate a long-time maxim that existed before the Magna Carta of nolo poene sine lege stricta. That means in penal law, there has to be a written statute on point before there can be a crime and before there can be punishment. You cannot analogize to other statutes. A1C and A2 have different elements and they serve different purposes. So that knocks out count 3, and that should knock out the sexual violent predator specification, count 3. Count 5, JM, that's the stepniece. There is similarly no evidence that she suffers from a physical condition or a mental condition. The only thing the state advances here is testimony with regard to her former school counselor who was not identified as an expert and who was not admitted into evidence as an expert, who opined that the school counselor's daughter suffers from Asperger's.
Counsel, what precedent should we rely on to say that you have to have expert testimony to show mental condition?
I think I don't know that you need expert testimony generally. However, I think when you're alluding to Asperger's, when that's the theory, I think just by its very nature, you would need expert testimony because you would have to be a medical doctor. That's a clinical diagnosis. That's not within the province of.
Do you have precedent for that?
We're asking this court to hold that in this case. We just think that that's a matter of common sense. I don't know that
even on a sufficiency analysis?
Yes, because that's purely an issue of law. So we ask the state, what is the mental condition in this case with regard to count 5?
So there has to be a label to the condition. Is that what you're saying? They can't describe the characteristics, the activities, the layperson's observations?
Correct, because a mental condition is something that is intrinsic to the victim. First of all, it's definitely not what they're arguing, which is a power dynamic or familiar relationship. So it can't be that, because that's under A2. It has to be, they have to identify the condition. What is the condition? Well, you know, that's the threshold question. What evidence do we need to get there is actually secondary. No condition has been identified in this case.
So you're saying we should make that determination, even though it's not in the statute, that we've got to, that in order to take advantage of this or to dispel it, there has to be the identification of a condition, and it has to be supported by competent medical evidence.
That's imbued in the statute. That's you cannot. That's just a common sense reading of the statute. There has to be a mental condition.
So a layperson's observation of the activity of a child over, you know, the growth several years, whatever the contact or experience is insufficient to determine that the child did not have the capacity.
Yes.
Okay.
Is the question, though, about the victim for count 5, is that really in front of us?
Yes.
I mean, the proposition specifically refers to the family relationship
Yes.
issue.
Because this court accepts cases and controversies, so there has to be some remedy. So if you adopt our proposition, then you just apply it to the case. So that
Why wouldn't we just send it back and say, we've answered the proposition of law, that gets rid of the familial, if we adopt your view, we would get rid of the familial relationship issue, and then all you're left with is this potential evidence as to another condition?
I think that would be an advisory opinion. This court is going to have to decide what the remedy is. I don't think you just answer the proposition, they abstract and send it back. In any sufficiency case.
Well, why couldn't we find that the error occurred when if we agree with you, it was insufficient at trial?
Sure.
So then you go back to when that occurred, that error occurred, and you still have count 4 as a conviction.
Here's
right?
why. Here's why, Your Honor. 294125 is the Allied Offense Statute. That statute is meant to prevent shotgun convictions. That's what the legislative history says. And the prosecutor has to elect. And so the prosecutor gets the benefit of a shotgun type indictment and to usher in all that evidence on all the different elements of the counts and increase the likelihood of a conviction of some sort. But with that benefit, there has to be some legal detriment that goes along with the benefit. And we believe that the prosecutor elects at his or her own peril. Otherwise, the election and the statute are thwarted. We're going to have endless litigation. There has to be some meaning given to the election. Otherwise, let's say they indicted a sexual offense 4 or 5 different ways, and there's 4 or 5 convictions. If the remedy here is just to send it back and start over, that just incentivizes the state to start with their weakest case, because we elect this case, and if that, you know what, we'll keep him in prison, and if that's not reversed, then we'll re-elect count 2, and if that's reversed, we'll re-elect count 3.
So, counsel, what you're saying is once the prosecutor elects which count to which count to attach the sentence to, the other count that was merged is no longer a reality. It's gone. And if the first count upon which the sentence is attached is reversed, then there is nothing left to attach a sentence to.
Yes, otherwise the purpose of 294125 would be totally thwarted, and the statute would then be a sword for the state.
What's the purpose of the statute? It's to limit the sanction to a fair result for the defendant.
Is to preserve judicial economy, Your Honor. If we're going to have continuous litigation over this, it defeats the purpose of the statute. The state has to elect. And
they did elect, and they did attach, and the court attached a sentence to the one count, and there was nothing to say the other one is dismissed, was there?
by operation of statute, we think that they merge. There can be one sentence under the statute.
And there
has
is
been
only one sentence.
Correct. And if it's remanded, there will be two sentences, and thus the statute is
Will
violated.
there be two sentences?
If we agree with you on count 3, how are there 2 sentences?
What the state is asking that you remand and have resentencing now on count 4, so that would be 2 sentences
But he's only serving one sentence.
right now. But the proposed remedy from the prosecutor,
He'll still only serve one sentence if you prevail on your count, and it's remanded for resentencing. The judge resentences. Presumably, there'll be credit for whatever time served, and the sentence would attach to the surviving count.
that would be 2 sentences. One that was issued a couple years ago, and then one into the future. Think of it this way. Let's assume the state elected count 4. Let's take a counterfactual, and they elected count 4. And let's say for some reason that count was reversed. And then you did what the state wants, which is go back down on count 3. And then that count is reversed. He's now
free.
He's now free, but look at the time.
But that happens in any appeal.
No, it doesn't happen in allied offense cases, which is the whole purpose of the statute. State, we're going to give you the benefit of indicting on multiple counts. We're going to let you bring in evidence of all that counts, but you have to pick, and you pick at your own peril. If that is not the law in Ohio, we're going to see an explosion in litigation, in allied offense litigation. To conserve judicial economy, we're asking that this court to hold in the remedy portion, pick at your own peril. And we think our proposition of law as adopted knocks out counts 3 and 5 and the specifications. We also believe, before I sit down, we also believe that if you knock out count 3 or count 5, that count 1 will remain intact as to the rape conviction, but that it has to be remanded for a limited remand under the sexual violent predator specification under count 1. And the reason that is we don't know how much weight the trial court put behind counts 3 and 5 when it made a determination under count 1 as to that specification. So we would have to speculate as to what the trial court would have done had 3 and 5 been knocked out at the trial court level. This court cannot speculate, so that's the part of the case that should be remanded. So our remedy, we're asking this court to adopt the proposition, instruct courts in Ohio to enforce A1C as it's written, can't be collapsed into A2 as the state is asking this court to do. Knock out counts 3 and 5 and the specs totally, and remand it for count 1. And then there's a new trial court judge in this case if it's remanded, and we think our client at that point would be able to elect a jury or a bench trial if this court is remanded for that purpose. If there's not any questions, I would reserve the remainder of my time for rebuttal.
Okay.
Thank you.
Mr. Harold?
Chief Justice O'Connor, members of the bench, may it please the court. We're here on proposition of law 2. The argument that we heard today concerned 4 propositions of law, 3 of which are not appropriately before this court. Justice French, to answer your question as to proposition of law 1, there is significant case law concerning substantial impairment as it relates to a mental or physical defect. In this case, pursuant to count 5, and count 5 relates to proposition 1, there was a finding that the individual here was low functioning. In fact, the Court of Appeals went even further to say that it was the low functioning issue, not the issue of Asperger's, that resulted in that conviction. If this court would like to look to a case where we have a familiar relationship with substantial impairment, I would encourage you to look at State versus Grayhack out of the 8th District from 2003. Proposition 3 was not raised here. That was sleep. Sleep is a substantial impairment. So as it relates to count 1 of the indictment, that is an appropriate conviction. Number 1, there was no proposition of law before this court dealing with the sexual violent predator specification. That was dealt with on appeal. The 6th District found manifest weight for that. I don't think that is properly before this court. Proposition of law 4, which again was not accepted by this court, which again was the first argument that was made, is to what happens with remedy. I would encourage you to look at State versus Powell. where interestingly enough, there was a sufficiency question, like we have here, over counts 3 and 4, like we have here, that were pled in the alternative. And the Powell court said, because, well, first off, the Powell court said we find sufficient evidence for count 3. But even if we didn't, there's count 4. So that seems to apply directly to this case with sufficiency argument as to the idea, if this court would find that there was not substantial impairment, which the state would argue there was, the result would be to remand and sentence on count 4. The idea that the conviction stands also comes out of State versus Whitfield at paragraph 27. The idea that even after the merger of the offenses, the conviction stands. There's an 8th District case, State versus White, that explains this very well, where the court said it must be more accurate to say, however, it is not the offenses that merge, but the sentences that merge. That takes us to Proposition 2, concerning whether or not a familial relationship based on this, because of the skewed power dynamic, creates a mental or physical condition.
Counsel, if I can just clarify as to
Absolutely.
count 5.
Yes.
There were 2 bases for convicting under count 5. One was low function, one is substantial impairment by familial relationship. I take it your argument is Prop 2 only gets us into the familial relationship, which leaves the substantial impairment by way of the low functioning. That's not on the table at this point, so we must affirm on count 5.
That is
Is
accurate.
that right? All right.
Correct.
Thank you.
So the question is whether or not there was sufficient evidence, the light most favorable to the state, to allow for a conviction for count 3 dealing with the stepdaughter for substantial impairment. I think the best law on this issue comes from foreign jurisdictions, because this is a case of first impression. People versus Cochran out of the state of California. Their substantial impairment is rape by duress as opposed to rape by force. And there the court said the very nature of duress is psychological coercion. That was followed in State versus Schulz as well, also out of California, also cited in the state's brief. Duress can arise from various circumstances, including the relationship between the defendant and the victim and their relative sizes and ages. So let's talk about relative sizes and ages. Mr. Horn was a laborer, was 40 years old, and was much larger than the 2 14-year-olds who he raped, one repeatedly. So I think under that argument,
Size, and what was the other one? Size and something.
size, age.
Age,
so,
size and- size and age.
14 to 40.
May not have anything to do with family, though, correct?
Correct. However, what we see is that in other cases, specifically, in that case, by the way, the Schulz case, the Cochran case, all those cases that were cited in the Cates brief, we're dealing with familial individuals, or at least people in a position of authority. And when you look at Eskridge and Dye, position of authority is what's used.
We're talking about mental and physical conditions.
Correct.
Okay? So a mental condition is a family relationship, a mental condition?
Yes.
Or is it just reality?
Well, I think yes in both. And that's why I encourage you to look at the cases out of California, out of Virginia, where they look at the special role that a family member plays. Again, in the cases that concern force, when this court found that the familial relationship or position of authority creates force, where we're looking at a stepfather or a mother's boyfriend or a biological father, I think all of those individuals, an uncle, stand in that position. And because there is that duty of obeying, the mental condition is the inability to resist. When we look at what the substantial impairment is, when we look at the issue of whether someone is drunk, their ability.
But Counselor, why do we even need to go there? Isn't there a provision of the code that already allows for the differences in the age and the relationship and the power or authority that the adult could display over particularly a child victim, and case laws replete on that, State versus Eskridge and his progeny? Why do we have to find that this is an impairment too?
Because on the facts of this case, in the situation that we have, I think both are applicable. Though I will say with Eskridge and Dye and Shame, the court created, through common law, it applied the statute.
For analysis of force.
For analysis of force as it relates to a familial relationship. This would be the exact same thing.
So aren't we treading down a dangerous path when we then decide that familial relationships can then be equated with a sort of impairment?
I don't think so, and here's why. The state is not asking for a per se rule. When you look at Eskridge and Shame and Dye, it is a per se rule with force where the individual is 13 and under. Okay. Here it would be fact specific. Every parental relationship does not create substantial impairment. But when you have the situation like you have here, where you have grooming, the count of the indictment that we're dealing with, count 3, is the 7th incident where Mr. Horn created the situation because of his position of authority to reduce the ability of the victim here to resist. And that's when you look at the cases, and again, I would encourage you to look at the cases from California, Virginia, the First Circuit, where they look at that familial relationship, and it deals with how can you resist. So the mental condition very much in that situation is the ability to resist the aggressor. Because the argument of...
The inability is based on fear. She feared, they were in a special relationship.
Yes.
She feared his reaction. She feared her mother's reaction in not believing her. Mm-hmm. And that's why she didn't, I'm not going to use the word acquiesce, but that's why it wasn't brought to light at that time.
Correct. And same thing, too, is when she reported it to the teacher did nothing.
So is fear an impairment?
I think when you look at fear and the concept of coercion and duress, what Virginia calls intimidation, I think all of those can be a substantial impairment if the facts are appropriate, much like it can be force when the facts are appropriate. When we look at, would be in Ohio law, 14 through a 20-year-old, force ceases to be per se. It's a key factor, but it's a factor. And I think when you look at that it can be a factor for substantial impairment. I think on the facts of the case, with what occurred with this relationship, I think that the familiar relationship did create the substantial impairment here. If there are no questions, thank you very much.
Thank you. Counsel, you have left about 2 minutes.
Okay, thank you. The indictment says that the substantial impairment was caused by a mental condition. That's the notice my client was given. It doesn't talk about...
So you're going to say that has to be diagnosed and it has to be medical testimony?
Well, it can't be fear because fear is under A2 and fear is an emotion. A mental condition is something intrinsic to the alleged victim, such as Down syndrome, something along those lines, and similarly, a physical condition is the same thing. It can't be a relationship. We know that because of A2. It's also not low functioning. The statute, if this court says low functioning satisfies O1C, it's violating the separation of powers because that would require addition of words into A1C that were omitted by the legislature, which this court has time and time again said it will not do. Furthermore, the substantial impairment has to be a mental or physical condition such that the person has an inability to resist or consent. There's no evidence of that on count 3 or 5. So the remedy is to vacate those counts. And back to Chief Justice O'Connor's question, will there still be one sentence? No. There's been a commitment to the prison system already. If we send this back down for a new commitment on another count or several other counts, we now have multiple sentences. That's not what the legislature intended in enacting 2941-25, because if it did, either the statute either wouldn't exist, or it would just say the unelected sentences automatically run concurrent with the elected sentences. What is the point of the state's election if the state's remedy is, that they propose in this case, is correct? There would be no point, and therefore there would be no point of the statute. The statute is to preserve judicial economy in cases of allied offenses. The state gets the benefit of bringing the allied offenses, but they get the detriment of having to elect at their own peril. And presumably a competent prosecutor would elect their absolute best case. I think that's what they did here, but count 3 and 5 are just insufficient evidence, which test the legal sufficiency of the evidence, which is purely a question of law. This is not a deferential standard of review or an abuse of discretion standard of review. The proposition accepted is a pure legal issue. If this court agrees with us, it should then apply that proposition to the case under the plain language of the statute and decide what the remedy should be. This case is teed up for this court to decide not only the proposition, but the remedy should be. So we're asking you to reverse the 6th District Court of Appeals and to hold that a mental or physical condition is something intrinsic to the defendant. There has to be evidence that this intrinsic issue causes an impairment such that the person cannot consent to sex. So if we say, well, low functioning, that means this person can never consent to sex. There is no, not just consent with this particular person, consent with everybody. Mr. Harold got up and talked about force. To Justice Stewart's question, this case at this point has nothing to do with force, and the reason is because the state, in electing the A1C conviction, has foregone that issue.
Thank you.
Thank you.
We'll take the matter under advisement, and you'll be notified of our decision. Marcia, we call a recess.
All rise.